Welcome to the Estate Blueprint, Planning Your Future with Tom Begley.
Welcome back to the Estate Blueprint, Planning Your Future with Tom Begley, where clarity meets compassion. Attorney Thomas D. Begley III is a certified elder law attorney with more than 35 years of experience helping families across New Jersey protect their assets and plan for long-term care. I'm Evan Mack, and today we're talking about the 5-year look-back rule, what triggers penalties, and how it actually impacts your ability to qualify for benefits. Tom, welcome, sir.
Good to be here, Evan. So, yeah, it's a big topic. It affects more and more people as years go on.
Yeah, so speaking of that, let's get into it. So what is that 5-year look-back rule in New Jersey, and why does it exist?
Yeah, so the 5-year look-back rule is actually a federal rule. Basically, Medicaid is often the optimal way to pay for long-term care. And so just to kind of get the audience a little bit of a background, about 70% of our adult population requires some form of long-term care at one point in their life, and about half of us receive some form of institutional care. And there are 5 ways to pay for that care. One is private pay. Second is long-term care insurance. The third is Medicare. The fourth is veterans benefits. And the fifth is Medicaid. For many of us, really the practical choices are private pay or Medicaid, because many people can't afford or they just don't have long-term care insurance. Medicare, a lot of people think will pay for much more than it does. It actually pays for what's called skilled care, which is when you're getting rehabilitation or have, a tube other with Foley catheter or open sores, and they pay 20 days and sometimes part of an additional 80. But after that, you're on your own. And for most people who go in for what's called custodial care, nothing. I mean, they do not cover a dime with that. So, and then veterans benefits, it does apply. It helps many, many people, but not everyone's a veteran. So for most people, that when they're dealing with the issue of long-term care, they're dealing with either watching everything they saved up for throughout the course of their lifetimes, vanish in long-term care costs in a relatively short period of time, or trying to get on Medicaid. And instead of waiting to get wiped out to get on Medicaid, there is some planning that can be done. So the big thing is, to go to your question, is the 5-year look back. The idea is to get on Medicaid in pretty much any state. It varies a little bit, but in New Jersey, it's $2,000 is what's called the resource cap. So you're allowed to have no more than $2,000 of what's called countable assets. So there are countable assets and non-countable assets, and they are exactly what they sound like. A countable asset is something that is counted by the Board of Social Services or the state Medicaid agency to determine whether or not you're eligible for Medicaid, and non-accountable ones are exempt. So the only one that's not exempt for anybody is personal effects. I mean, unless you've got the Hope Diamond stuffed in the living room, you're okay. If you're married, a one house and one car can be considered exempt so long as that's being used by the healthy spouse. But for single people, that's not the case. And anything else, whether you're married or not, pretty much your liquid assets or additional real estate that you might own, that's all considered to be countable assets. So if you've gotten a home, for example, over the years and several $100,000 or more, the idea is if you wind up getting sick and need long-term care, especially outside of the home, the idea is that you need to gift assets. And you could either gift assets outright to beneficiaries, typically children, or into a trust for their benefit. However, you can't just do it one day and throw your arms up in the air the next day and cry poor mouth to the Board of Social Services and say, I'm eligible for Medicaid. The idea with the government is that in order to get on long-term care benefits, their idea is that your assets should be used to pay for your care prior to the state or federal government picking up the tab for your care. So that's why the 5-year look back came into being. For many years, it was the 3-year look back, but for the last 20 years now, it's been 5 years. And what that means is that if you apply for Medicaid, when you apply, one of the questions will be, have you given away assets for, less than fair market value, i.e. gifts, in the past 5 years? Now, if the answer is no, then you move on and hopefully you're eligible for Medicaid if you're less than that $2,000 resource limit. On the other hand, if the question is yes, then a period of ineligibility is calculated, which renders you ineligible for Medicaid for a period of time. So there are a couple things to really know about that. One is that if you're going to do any gifting, with certain exceptions, which we can go into shortly, with the exceptions of a few things. You need to make sure you get it done 5 years before applying for Medicaid, because the second concept is when they calculate the penalty, they don't calculate from when the gift is made, which is what they used to do. What they do is they calculate it from the time that you make a application. So, Evan, for example, if I, 4 years ago gave you $100,000 and you apply for Medicaid on my behalf because I'm incapacitated and I need to go to a nursing home. When you apply, if they ask, did Tom make any gifts in the last 5 years? You'll say, yes, he did. And 4 years ago, he gave me $100,000. Well, they're going to calculate a period of ineligibility of, maybe, 8 or 10 months, but they're going to actually say that 8 or 10 month penalty is starting now when you apply for Medicaid. The problem is I don't have the money anymore. And which basically means you're kind of stuck with the bill. And you look at the factor that the state uses in order to calculate your period of ineligibility, it's considered the average nursing home cost. But when you average everything out, they put into account, assisted living facilities and, other lower cost options. So ironically, you could wind up having to pay back more money than you received. So it's really, really important to understand the 5 year look back, when it applies and when it doesn't, and then what to do when it does apply.
What makes a transfer count as a violation under Medicaid rules?
Okay, well, so the transfer is basically if you make it for less than fair market value. So a lot of people will come and say, for example, hey, what if I sell my house to my kids for $1? Well, the state's not going to say, God, the kids were great negotiators and they really, twisted mom's arm and able to get her to give her such a great deal. No, anything that's considered a gift. So if the house is worth $300,000, that's considered a $300,000 gift. So basically, there are several exceptions as to the 5 year look back. So this would probably be a good time to kind of talk about what doesn't. So basically, really, the answer is anything that doesn't come across under these coming exceptions does qualify to be considered a gift that violates the 5 year look back or the Medicaid rules. So one exception is a house for so long as it goes to a spouse. So if, for example, something happens and your wife was incapacitated and you own the home in your name, you could take the property out of both of your names and transfer it just into your name. And that's an exception to the 5 year look back. Also, you can keep liquid assets or countable assets as a couple up to a certain dollar value with a certain minimum known as the community's spouse resource allowance. The big exceptions are if you are blind, disabled, or a minor. In that particular case, transfers to those three classes are exempt. A lot of times you don't see the ones involving age very often because people that are basically in their 80s and 90s don't have children that are 18 or 21 or below. And I mean, there are some that do qualify as blind, but the big one you do see is a disability. For example, I have a case where recently we're getting somebody on Medicaid benefits, and he basically lives in his home locally with his adult daughter. And the home is free and clear. It's worth a few $100,000. All the liquid assets are down to $2,000. But we're actually going to take the home and transfer it into the name of the disabled daughter. And that's going to work out because there's no look back period. There's a look back period, but it's considered an exempt transfer. And that's going to allow the father to go ahead and get in-home care. So there are certain things, there are some other exceptions as well. But outside of that, pretty much anything you do as far as giving money away for less than fair market value or assets away for less than fair market value is considered a gift, and that gift is subject to look back. And basically, you want to make sure, with the exception of the exceptions that I just gave you, no pun intended, that you make those gifts, 5 years prior to making an application for Medicaid benefits.
What are some of the most common mistakes people make without realizing they've even created a problem in your experience, Tom?
There's a couple interesting ones that always stand out. One is that they, apply for Medicaid too early, they don't wait for that 5-year look back. I had a case with another firm where one of the attorneys had the guy was a professional and he was very smart and was a very successful doctor in the year, really nice guy. And his parents both needed long-term care. They transferred a substantial amount of money. And then, the nursing home where they were both staying at, approached him and said, it's about time for you to apply for Medicaid. Now, when you have something that complex, typically many individuals will hire a law office or a Medicaid consultant to actually do the application, make sure that nothing goes awry. In this case, he needed to wait a couple more months to file the application, but he just kind of wanted to check the box. And unfortunately, in this area of, do it yourself, he decided to do it himself, which was ridiculous because, the amount was transferred was a lot of money, and he was already independently wealthy. But what happened was because he applied for Medicaid 4 years and 10 months after the gifts were made, when the application was denied by the county and the state, they denied it because of the vast amount. And this is crazy because of what it transferred. Mom and dad were both made ineligible for Medicaid for, a drum roll please, 12 years. Wow. So the idea is you must not apply for Medicaid until it is time. And that's really where you need to rely upon a professional. Another thing that you see, which is sad, sometimes people have a misconception that once you enter into a nursing home, that you can no longer make gifts. And that's not true. The look back really just means that if you're going to make gifts, you need to make them prior to 5 years application to for Medicaid benefits. So some people have substantial assets, and sure, during 5 years, that's going to cost you some decent coin. On the other hand, a lot of times you can do a calculation and at least realize that you can gift the amount over what is necessary for 5 years, so that at the end of the 5-year period, at least you stop paying.
Are there any transfers that are allowed without triggering a penalty?
So the ones that trigger without a penalty are the exempt ones I alluded to earlier. One, of course, is the transfers between husband and wife for real estate, also for an automobile. Transfers to primarily a disabled child or a trust for that disabled child's benefit. Another one, although you have to document it very well, is what's called the caregiver child exception. So, for example, if mom is failing with her health, and let's say she's widowed, and one of the children comes in and moves in with her, and provides a level of care that keeps mom out of a nursing home for a period of at least 2 years, then the house can be transferred to that child, and that would be considered exempt at that particular point. Another one is a purchase of what's called a life estate. So, and that's basically where, let's say dad's slowing down. He knows he may need care in a nursing home one day, but he's going to go move in with one of his kids. And there's a table that will, based on how much the house is worth and the age of dad, and they will calculate how much dad can actually give to the child, and that's the life estate is the right to live there till the date of death. Now, as far as the estate is concerned, it certainly has to be based on an actually sound principle, but recognizing that people do go into a nursing home, that after a certain period of time elapses, if someone goes to a nursing home, that purchase of a life estate is considered to be exempt. It's a 1-year rule, so the idea is, and it's strict. So literally, if dad comes to live with you, and after 11 months and 29 days, dad needs to go into a nursing home, they don't prorate at the state. So we better make sure that dad stays there for a year. So there are some exceptions. The big thing, I think, Evan, is that you need to know when to plan because of the length of look back. So to the extent it's helpful, I've always thought that there are 2 primary populations that go into nursing homes and assisted living facilities. Now, I know there's some exceptions, but the 2 primary populations first are the massive stroke victims. And I'm not talking about the person who has a serious stroke and goes to the hospital, then to a rehab center, then is able to come home and have a pretty decent life or some level of quality of life. I'm talking about the person really that has just the traumatic stroke that they're going to be gone in a few months. I mean, there's no planning that makes sense whatsoever. The big population that you can plan for, and you do have time to plan for, are individuals that have Alzheimer's and other forms of cognitive deficits. Back in the early 1990s, when I was first starting to practice law, Alzheimer's progressed much more quickly than it does today. And typically, if somebody was diagnosed with Alzheimer's, they were gone within 7 years, usually went to a nursing home within a year or two. Now, because of the advances in pharmaceuticals and medicine, many people now are able to stay in the home environment for several years before they need that care. So I tell people, when you get that diagnosis, you've got what we call the warning shot. That's when you run, you don't walk to the attorney's office and plan a very responsible way to divest assets. Now, the other thing you could also consider doing is looking at that issue with your attorney. I always tell people, when you're younger, take a look at your, wills and estate planning documents, every 5 years. But once you hit, say, 70, 75, you should take a look at them every 3 years. And a decent attorney who specializes or concentrates their practice in the area is going to know to ask you not just about, what's in the documents, but, what's going on in your life. And if somebody says, I'm starting to slow down, well, sometimes when somebody's in their late 70s, early 80s, maybe cognitively they're okay, but just physically things are starting to, go awry, as happens with age. My grandfather, God rest his soul, had a great line when he turned 80. He said, the warranty on the parts is starting to expire. But when that happens, that's sometimes when you can start considering making some movements. So, the big takeaway, I think, from today is twofold. One is, if you're going to do gifts, if they're not exempt gifts, make sure you wait 5 years before you apply for Medicaid after making them. And secondly, plan early. Don't wait until it's too late.
What should someone understand before moving assets if long-term care may be needed in the future?
So as far as moving the assets, if you're going to do that, you should make sure that two critical areas are covered. First, you just can't transfer your assets to anyone. More often than not, we have cases where mom and dad, they're married, they've got a handful of kids, and they want to treat all the kids equally when they're gone, but while they're alive, it may be risky to transfer outright to children, because we've had cases where someone, for example, gave the house to the kids as part of a gift, and then at the end of the look back, they got on Medicaid, but when it was time to sell the house, two things happened. One was the person passed away, and then the son-in-law and daughter-in-law owned a piece of the house, which nobody ever wants. And the second thing occurred was that we have a son or a daughter who has financial issues. So you could be jeopardizing family assets. So one thing I always recommend is that any gifts, to the extent possible, be put into a trust. And that way it's, there, during the course of, the parent's lifetime, but it won't be distributed till after they're on Medicaid or after they died. And when it's done that way, we're not worried about any liens, being placed. So that's a big concept, to cover.
Good stuff, Thomas. Appreciate the time.
It's always good to be here, Evan.
That's it for today's episode of the Estate Blueprint, Planning Your Future with Tom Begley. If you'd like to learn more about how Tom Begley and his team can help you navigate Medicaid planning and protect your assets, visit Begley3law.com. Thanks for listening, and don't forget to leave a review, subscribe to the show so you do not miss the next episode. Thank you so much, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.